I had some brief thoughts. I'm not sure I have good answers to any of these. I'll note, though, that the Bate Din in America are very good at complying with procedural due process. All of the Bate Din are experts at complying with the procedural due process laws of the state. If you don't get good at it, you get out of business. Eretz Chemda is a derivative of the Beth Din of America in terms of personnel and in terms of approach. So I'm glad that they're good at it too. But putting aside procedural due process, the question of substantive law lurks at the background. America has a much weaker doctrine of public policy. Precisely because we are a federalized jurisdiction, we don't have a clear sense in America that I can't agree to be adjudicated by French law, even if French law violates American law. I'll give you a simple example. A man dies in California, and he's in a polygamous marriage conducted in India, but he's living in California. Should California enforce his will, which leaves his money equally divided between his two wives? California says, want to guess? Yes, of course. Even though polygamy violates the public policy of the United States, California says it's not important. It's not important. We have much weaker doctrines of public policy in the United States. I think it's because we are ourselves a federated system, so we don't think the law in the state of Georgia is correct. We think it's just the law. And when you agree to be adjudicated by some other law, you agreed. That's good enough. And so there's much less public policy issues.
אומנם בין ציבורים בגלל ב-95% מתיקי הבורר, אני טיפלתי בתיק אחד או שניים, ושם אני פסלתי בורר שהצהיר שהוא לא מוכן לקבל את הדוקטרינה של שיתוף נכסים בין בני הזוג, ואמרתי שיחליפו לבורר אחר, כי אף אחד לא מוכן לקבל בוררות שמתנהלת בבסיס ההנחה שהדיין, וזה היה רב, אמרתי תלכו לרב אחר שיסכים, לא תלכו שהבורר לא יהיה רב. לא יכול להיות שאישה תסכים לנהל בוררות על בסיס ההנחה שיוצאת עם אפס.
Okay. I don't know why, though, if they had a prenuptial...
בית המשפט לא נשאר את זה.
Okay.
בגלל תקנת הציבור, לא בגלל שלא ייתכן שהיא תסכים, יכול להיות שהיא תסכים, אבל תקנת הציבור.
זה לא כמו שזה לא הסכמה מודעת.
I just don't know why.
או שזה בלחץ.
זה אחד המקרים הנדירים שבית המשפט העליון הגישו ערעור והוא אישר אותו.
If they had a prenuptial agreement in which she agreed that she would walk away with nothing, would that be okay? Yes?
Yes, yes.
So why should this be any different? An agreement to go to a bait din that'll give her nothing is no different than...
it wouldn't be okay. למה אמרת כן? It wouldn't be okay.
יש מנהל שאומרים שיכול הדין היהודי שיהיה נכסי מלוג ונכסי צאן ברזל והיא לא הביאה שום דבר.
אמרת זה נגד תקנת הציבור.
לא, אני אומרת שרוצה שיהיה נכסי מלוג ונכסי צאן ברזל והיא לא הכניסה כלום, אז זו התוצאה שיהיה לה כלום.
My third comment goes as follows. My third comment goes as follows. You feel a sense of ownership over the secular law. That's what you're doing here. That's what to some extent, mishpat Avri. You have a vision for what the secular law should look like. In America, that vision isn't there. Neither the Jews nor the Protestants nor anybody else has a vision of what secular law should look like. So we don't care about this issue. You care about the secular law in Israel. That's nice. That's an interesting thing. I guess I find that kind of curious, kind of cute. Makes you religious Zionist. But really, who cares?
America is not a Jewish state, but Israel is a Jewish state.
Who cares? This is what makes Mishpat Avri so interesting. I understand. I heard this from Menachem Elon as well many years ago. It was kind of cute, even when I heard it from Menachem Elon many years ago.
You sure you want to use that word?
Cute in the sense of it.
It's a bit patronizing.
No, I don't mean it in a patronizing way. God forbid. I mean it's an approach. But in the United States, we don't care about the content of secular law. And we don't perceive ourselves as enforcers of public policy. We play the game by the rules. The Federal Arbitration Act doesn't impose upon arbitrators a duty to do this. It doesn't impose upon secular arbitrators. It doesn't impose upon religious arbitrators. And we play the game by the rules. If the government wants us...
זה games of rules. אנחנו לא רואים את ההליך המשפטי בתור game אנחנו רואים את זה כעניין רציני, ואנחנו רואים את מה שקורה במדינת ישראל כעניין רציני. זה לא גיים וזה לא רול, אלא זה עניין, כמו שאמר בציון גרינברג, אז הוא צריך לגייס בצדק, וגם אני קצת כועס.
אני לא כועס, חלילה.
לא, לא. מביע עמדה strongly.
I'm glad that you feel that way. I'm not opposed to that. I don't feel that way. I don't feel that way in America, and honestly, I don't particularly feel that way here either. I don't live here, so it's not my home. But in the United States, I view the law within certain parameters on financial matters as rules of the game. And the rules of the game are enforced. By the way, secular law views itself that way. That's why the Federal Arbitration Act not just permits Jewish law. It permits any legal system that you and I agree to. You and I agree to go to arbitration, and we agree that the arbitrator will rule the opposite of American law. That's what our arbitration agreement says. We agree that if the arbitrator shall rule exactly what he thinks is the opposite of secular law. So you would say that that should not be enforced.
And you would?
Not only would we, a secular court would accept that.
Also he would accept it. אז למה היית מקבל את זה?
That's exactly meaning.
לא, זה בפירוש לא נכון.
Let me give you the following example.
If two parties were to sign an arbitration agreement that said the arbitrator shall decide this dispute
by rolling the dice,
by the best of his ability, and then he will give a psak din that will be the opposite of what he decided.
Let's take a much simpler case. Two partners agree that every time they have a dispute, let me take a very simple case. Two parties agree that every time they have a dispute, they roll the dice. And if it's an odd number, this partner wins, and if it's an even number, this partner wins. That's totally acceptable. That's totally acceptable. That's totally acceptable because the parties agreed to it. Don't miss the fact that if you don't want that legal system, don't sign. If you sign an agreement in which you and I will do business and we agree whenever there's a dispute, we'll roll the dice, you agreed, I agreed, that's it. What more do you want? The essence of law is agreement. It's a very different model than what you're thinking about. That's fine. I don't mean it in a patronizing way, but the heart of this dispute is about whether you think you're looking for truth or you're looking for... So when it comes to, you're asking an excellent question, the answer is as follows. No, child custody, because the children cannot sign, is adjudicated by the best interest of the party. But this is very important to understand. Financial disputes, that's your watch. I say it's mine. You and I agree that we'll roll the dice. And if it comes up even, it's mine. If it comes up odd, it's yours. American law says, great. You and I agreed to that. If you didn't want to agree to that, don't sign. If you signed, it's because you accept that that's the rule. I understand that that looks very different because you're searching for truth. But we are searching for agreement.
But even in contract law, there's a limit to how far you can take arbitrariness as being a basis for a contract that's going to be enforceable.
So I'll agree. In the United States, that unconscionability comes in when we use doctrines that we violate procedural due process. Like if I agree that when there's a dispute between us, whoever is whiter wins. American law would treat that as violative of procedural due process. But there have been countless arbitration agreements that involve arbitrariness that the secular courts have upheld. I'll give you sort of a classical sports one. The NBA moved to the following jump ball rule. Does any of this, you know what this is? Mishu medaber Greek. Kadarsal. I'm going to explain to you, I'm sorry, really, I can't do this in Hebrew. But the rule in basketball now is as follows. When we have a jump ball, we take turns winning. The first time it's a jump ball, it goes to the home team. The second time it's a jump ball, it goes to the visiting team. The third time it's a jump ball, it goes to the home team. The fourth time it's a jump ball, it goes to the visiting team. That's totally not fair. The umpire should determine who's the winner and who's the loser. Why should we ever allow it to rotate? So there have been court cases on
It's a
this.
rule of convenience on that, you know.
They say as follows, it's not a rule of convenience, it's a rule of agreement. If you don't want to play the game that way, don't take the field. Every rule is just a rule of convenience if you sign the contract. Now the only time that's not true in the United States is when I invoke things like race or other things that American law treats as foundational to fairness. There's an ongoing dispute, by the way, in the United States about the following rule. We agree, you and I sign a contract in which we agree women's testimony will not be accepted. Should the courts allow that? Most say no. Most say no because it violates the anti-discrimination clause. But if we sign an agreement which limits who can testify in ways that are non-discriminatory,
Well, they'll interfere with if you say a guy who is not Shomer Shabbos is Pasal Ha'edus, they'll interfere with that?
I'm not sure about a guy who's not Shomer Shabbat, but I'm pretty sure they would say this with regard to gender because it violates the federal discrimination statute. But I'm not 100% sure. But I understand the gap between us. We're looking at things very differently. You're looking for truth, and I'm looking for contract.
אני רוצה להעיר, אחת הנקודות פה שעיקר הוויכוח נסוב עליה זה הנושא של אי חוקיות וההתערבות של בתי הדין הרבניים הפרטיים בסכסוכים כאלה, וצריך אולי להעיר משהו לגבי הפן ההלכתי ולא רק לגבי ההבדל בין המערכות הישראלית והאמריקאית. הרי בסופו של דבר, ואם אני מצטט דברים מהספר של פרופסור שוחטמן, הרי בסופו של דבר צודק פרופסור ברויד שבתי הדין הרבניים אמורים לפסוק בסכסוכים כספיים בין עבריינים, ויש לנו דוגמאות כאלה של סכסוכים של חילול שבת וזנות ודברים כאלה, ובשונה משיטות אחרות, בתי הדין הרבניים אמורים לפסוק בסכסוכים כספיים בין עבריינים. אבל מה שצריך להוסיף, שההלכה יכולה להחליט את זה לעצמה, משום שהיא גם מורה שבהיבט הפלילי בית הדין צריך להעניש את הצדדים על כך. כלומר, כאשר שניים סוחרים בשבת, אז יגיד הרמב"ם שאנחנו צריכים לאכוף את החוזה, אבל ללקוט אותם על מסחר בשבת או משהו כזה. כלומר, הפן הפלילי משלים פה את הפן האזרחי.
אין לך סמכות פלילית.
עכשיו, מה שקורה כאן, כשאין לך סמכות פלילית ואתה פוסק את הדין שלהם, אז אתה הופך להיות בעצם שותף לדבר עבירה. כלומר,
אתה מאבד את התוצאה.
אתה מאבד את התוצאה. כלומר, ההלכה במקורה היא דואגת לכך
זה המצב בארצות הברית גם.
Of course.
אז לכן זה כל כך בעייתי.
הלכתית זה בעיה.
But we don't
הלכתית זה
care
בעיה.
about the fact that you're doing drugs. That's not our problem.
but I think-
Why does that even violate halacha?
No,
Because of Dina de Malchuta?
So let the Dina de Malchuta enforce it. They're the owners of the system, not us.
I think one
You
of
don't
the
have a
things
religious
that's
obligation to Dina de Malchuta?
If the government tells me that I have to enforce the law, then I have an obligation. If the government says I don't have to enforce the law, then I don't have to enforce the law. Meaning, in the United States, when I watch you deal drugs with him, I'm under no obligation to call the police.
But you're also not permitted to actively assist him.
That's wrong. I'm not permitted to assist him by handing you the drugs, but American law permits me to adjudicate the financial dispute between the two of you about the drugs.
Okay.
If American law didn't permit this, then we wouldn't do it. When the American law does not permit it, then we don't adjudicate them. Of course. There are, by the way, some areas where American law does not permit this adjudication. Like, for example, in discrimination lawsuits, the federal courts have said no arbitration. There are a few areas where the government has said this, where the government said no arbitration. But in general, the government said do whatever you want. And so they've said, since the government has said I'm not responsible, I take it seriously. I listen to the government. It says I'm not responsible.
I think one of the things that could be being echoed here a little bit is not just the fact that Greenberger and some are part of the state apparatus per se, but one of the I think more famous theses going on or that have been voiced in Israel is one of the problems that lie at the basis of Israeli new Zionist society is we came from a galut background where we were always trying just to worry about ourselves and to, not to pay the taxes and not necessarily do everything Goyim would want us to do and things like that and get away with whatever we can. And somehow we have to, out of that, as a phoenix or whatever, try to build a society where we do care about public policy, we do care about what's going on larger than the specific monetary problems here. And that's perhaps why you're hearing some of the reticence of this idea of that it's okay especially for a Jewish court to say, you know what, criminals are fine with us as long as the arbitration statute doesn't specifically say that we have to tell them, then we won't. And we'll take what we can get and we'll allow these Jews to go along doing their thing. And in the state of Israel, you can understand why that kind of a thing, even for a more private Beit Din, would be problematic for us, even if it was, totally private and there were less public Batei Din, because we do have a to the more general thing.
And by the way, in the last 10 years in the United States, states have enacted laws which say even private tribunals have to report child molestation, for example. To give you an example, it's not that the government never does this, but it generally doesn't do it. I'm just meaning it's the exception rather than the rule. Child molestation.
How an arbitration like that, Ron? Just it sounds very interesting. You got two car thieves that are before you, and each one's arguing that the money belongs to them.
Yeah.
And in order for the dayan to decide, he has to hear testimony about what's accepted in the criminal milieu, about who the money should belong to,
Sure.
and what the proceeds of the thefts are, and everything about how the whole criminal activity works.
Sure.
And then the dayan has to work and say, no, the criminal activity works this way and not that way.
Why is that any different from figuring out how the dentistry business works?
מנהג הסוחרים.
Yeah.
I don't understand. I don't understand. Car thieves have traditions and practices
There's
as well.
honor among thieves.
No, absolutely not. There's no honor, but there is practice. I don't understand. I've heard lots of adjudications in which, oh my gosh, people are lying. If you hear cases all the time, you learn
That's true.
who's telling the truth.
Almost 50%, yes, we know.
People lie.
50%, yeah.
לא, אני אומר, אמרתי בתחיל.
יש מישהו שבאמת פה?
I'm curious about child custody cases in which you arbitrate.
לא.
Child custody cases are adjudicated by the best interest of the child.
Yes, but it's also contractual.
Yes.
So what happens if, in that case, it's a contract and it
But in that case,
followed by
the state imposes upon us the standard.
Oh. So that's a case. That's a
in Israel,
specific
you
case.
can't arbitrate child custody.
I understand, but in the United
America,
States you
can
can.
arbitrate child custody,
So-
but you can't deviate
But it's
from the standard.
scrutinized if necessary.
And you have to write an opinion
I
explaining
see.
why this is in the child's best interest.
And then you use social workers and all the rest of it?
You try, the better ones do, sure. Meaning, in child custody, you can arbitrate, but you have to write an opinion explaining why your placement is in the best interest of the child. Now, I'll share with you a secret, Yaakov, which is, I write them all the time. I've never been reversed on a child custody matter either, and I'll tell you why. Judges in America are lazy. I guess we should turn off the camera. They see that I'm a law professor, and I write an opinion. And I say, I did this, and I did this, and I did this, and this is my conclusion. So the judge, you know what he can say? I can do it all over again.
Or not.
Or not. And if I do it all over again, then you know what I have to do? I have to do it all over again.
So would a family court judge be the one to hear?
Yes, but it's just, he says, oh, and then I have another case? And Professor Broyd has heard this matter already, and he said he did A, B, C, D, E, F, and G. Should I do it all over again? Doing it all over again is expensive and time-consuming and this and that. I'll just affirm it. I'll say it has an adequate basis in the facts
In
law.
any cases of family law to us, we are doing just the same. We read all this from A to Z. This is our job to do. We are
Okay.
not lazy, as you
משה
said.
עכשיו הזכיר את המילה appeal, ואני רציתי להעיר הערה קצרה. אחד מהנקודות שאתה הזכרת ברשימה שהזכרתי קודם, זה שרצוי שכל מערכת של בוררות של בתי דין תורניים, שיהיה בה מרכיב של ערעור פנימי. כן. עכשיו, ערעור פנימי זה תופעה שנוצרה בארץ רק לאחרונה בתיקון לחוק הבוררות, וזה מחייב הסכמה פוזיטיבית בהסכם שפסק הבוררות יהיה נתון לערעור. בבתי הדין הממוניים אין ערעור. יש משהו אחר לגמרי. יש דיון חוזר אחרי שנתנו פסק הדין, מישהו תגיד, רגע, אבל יש לי עוד איזה ראייה, אז אין סופיות הדיון בהלכה, ולכן פותחים אותם בוררים, פותחים שוב ושוב ושוב את ההליך, וכל פעם מוצאים עוד פסק דין ועוד פסק דין ועוד פסק דין, ואז כשזה בא לבית המשפט לביטול, השאלה היא מתי, איפה אני עושה את הסטופ, שיש פסק דין סופי של בוררות שאני יכול להתמודד איתו, אם זה פסק ביניים או זה פסק סופי, אבל ערעור אין.
The Christian courts don't have appeals, but they have reconsideration, just like they do here. In the United States, the Christian arbitration tribunals do not allow appeals, because since the Christian arbitrator is Christ embodied, how can you appeal from Christ embodied? You can only ask Christ to reconsider. Can't go above Christ.
להבדיל אלף אלפי הבדלות.
I understand.
כשניתן פסק דין בדין תורה, אז בעצם אלוקים מדבר מגרונו של הדיין.
This is where they
זה
get it
פעולה
from.
דתית.
But nonetheless, we allow appeal to a better God.
אוקיי.
A better God.
Our God.
But you're right, it's very interesting.
זה סם.
רבותיי, תודה רבה. כמעט הגיע הזמן קריאת שמע של שחרית, בטח של עברית.
זה היה מאוד טוב.
היה דיון מרתק ותם ולא נשלם, ונקווה להמשיך את זה בהזדמנות נוספות. אז תודה רבה לפרופסור ברויד, תודה רבה לשופט גרינברגר, ונשמח להמשיך את הדיון.
לא אמרת בו בצחוק, יש בו באמת...